Good afternoon, everyone. You're very welcome to this in the latest series of our legal webinars, Charities, Funding Cuts and Insolvency in the Third Sector. We're delighted to have Sam Corbett and Chris Coulter from Goodbody to talk to us about this. They're both very experienced in the field, particularly within insolvency, which unfortunately is becoming more and more prevalent, and particularly within the charity sector, unfortunately. Maybe just before Sam kicks off, a wee bit of housekeeping. If you could please ensure that you have any questions, we'll have a Q&A session at the end. If those could go into put those in the question box and not the chat, please. It's easier for us to pick them up. And again, just a wee plug from the Ulster Society. There was an e-news bulletin went out yesterday with a link calling for members who want to sit in voluntary boards. So just to remind you about that, if you could complete that, please, if you're at all interested. So without further ado, can I please ask Sam to commence the webinar and start sharing the screen? Thank you, Sam.
Thank you, Rosemary, for the introduction, and good afternoon, everyone. Before we begin, I think it would be useful for Chris and I to briefly introduce ourselves. As you can see from this opening slide, my name is Sam Corbett, and I'm a partner in the Belfast office of Goodbody, and I'm predominantly responsible for heading up the restructuring and solvency team. And I'm joined here today by one of the solicitors in my team, Chris Coulter. Right across our team, we have extensive experience of the restructuring and solvency market, and we've acted in some notable and complex restructuring mandates in the island of Ireland for the last 15 years, some of which have been in the third sector. And that takes us nicely to the topic of today's webinar. It, I'm sure, will come as no surprise to any of you that the number of charities in financial difficulty is expected to rise this year. In fact, research undertaken by Charities Aid Foundation has shown that more than half of charities surveyed are saying two things. One, they're worried about their ability to survive. And two, they're already beginning to use reserves to cover core costs. And I suppose it's with that in mind that the Ulster Society has asked us to deliver a webinar this afternoon focusing on funding cuts and insolvency in the third sector. And the good news for all of you is, even though we're both lawyers, we're both going to try and keep as little to no law within this presentation. The bad news, though, is that the third sector, like all sectors, needs to brace itself for what might be about to arrive. I don't think in 25 years we have seen worse market conditions, but rather than paint a picture of doom and gloom, we've tried to approach this webinar from the point of view of recovery, not insolvency. In fact, I'm sure you'll have noted from the cover slide with the cars all zooming around that we've entitled this The Road to Recovery. Because over the next 35-40 minutes, what Chris and I hope to provide you with is practical guidance around planning and safeguarding that can be put in place by charity trustees, so as to enable you, if you are a charity trustee, or the businesses you advise if they're charities, to avoid the road to ruin and stay on the road to recovery. But firstly, let's start with why. Why is it that I say the charity sector is expected to have a difficult 2023? And why is it that restructuring and insolvency advisors and commentators are saying that a recession is coming? Well, let's contrast the market conditions of May 2023 to what they were 3 years ago in May 2020. In May 2020, we had record low interest rates. They were at 0.1%, if you can remember that. Inflation was low. It was at 0.7%. Creditors couldn't do anything. They were restricted. There was pretty much a freeze on activity at the courts, both creditors and landlords. We had a very friendly government. I think that's exemplified, I suppose, amongst other things, by the 370 billion of liquidity that we had injected into the market. We had, albeit it does seem hard to remember, a functioning executive back in May 2020. Living costs were low. And finally, don't underestimate the intangible. There was confidence. Even though the pandemic had started at this stage, there was confidence in the market, and that can often be a key difference. And back in 2020, the Charity Commission and others, myself included, did have fears for the charity sector, mainly to do with the commencement of COVID lockdowns and how charities would be able to generate income. But those fears were premature, as we didn't actually experience the difficult market conditions that many expected. In fact, many charities and some of the charities that we advised in this period, despite this uncertainty, did really well. And they did really well around income generation, and would reflect that this was quite a positive period for them. But fast forward 3 years, and there is, however, a stark market contrast. Higher interest rates, The base rate's now 4.5%, up from 0.1. We have high inflation, it's 10.1% from 0.7. And just last month, we saw the lifting of restrictions within Northern Ireland. And those restrictions were lifted in England and Wales over a year ago. And if the lessons from England are anything to go by, the road ahead could be quite bumpy in Northern Ireland. England recorded a 150% increase in insolvencies last year, and their statistics were the second highest ever annual insolvencies on record. 2009 was the only year ahead of it. And if those factors alone were not bad enough for the third sector, we're now seeing government sympathy waning. And for charities and those in the third sector, the impact on public finance cuts and funding grants is self-evident. There's also, if we continue on down, no functioning executive to assist or aid the third sector. And not only have living costs increased, but we've moved from low living costs to a cost of living crisis in 3 years. To be honest, and I said I didn't want to talk about doom and gloom, the market conditions couldn't be worse, and they aren't helped again by continual instability in the market, whether that be locally from Brexit or the protocol, or whether it be a more macro level where you have an ongoing war in Ukraine or failing banks, Credit Suisse and Silicon Valley. So in terms of setting the scene, why this webinar is important at this stage, the market conditions are as bad as they could be. And we see this played out in the headlines. The BBC's highlighted the impact of Brexit. Under, as many of you will know, under the European Social Fund, community organisations in Northern Ireland receive 40 million annually. The UK's replacement, the Shared Prosperity Fund, is only providing 57 million into the UK over 2 years. So charities have been levelled down, not up. And at the same time, government funding is being cut. This is exacerbated by the absence of an executive, with departments only confirming their budget to the end of June, not a full financial year. And then, of course, we have the role that the cost of living crisis having. The Guardian, I suppose perhaps as expected, are criticising the Tories for placing increased pressure on charities during the cost of living crisis, which is some surprise to us the Daily Express agrees with, but as you'll see in more neutral terms. So that is a bit of a scene setter as to what the market conditions are like. But before we get into looking at what some planning and safeguarding may look like for charities and charity trustees, it's important to always assess where you find yourself on the road. So before we assess where a charity might find itself on the road when financial distress hits, it's important to look at, well, what are the various stages of business recovery? And where are you if you are within a charity, or where is your client if you're advising a charity? If you can imagine the growth stage of a charity is climbing the hill, and they come to the top of the hill and they have this fork in the road, the first signpost that a charity, or suppose any business for any matter, is in financial distress will experience is underperformance. Underperformance is the first warning sign. And if that isn't addressed, that leads to distress. And if distress isn't addressed, then ultimately the fork in the road comes in the form of a crisis. But at that stage, the charity has a choice to make. A choice to go down the road of recovery, which involves taking action and involves crisis management. And this might not allow the charity to turn the corner immediately, but it helps it stabilise and focus on the road to recovery. But to get onto that road, planning and safeguarding needs to start right from the outset, when it's solvent, not just when underperformance and distress hits. So when it's climbing the hill, not when it comes to the top of the hill. And if those plans and safeguarding measures are in place, then a charity will be well placed to avoid what we term the road to ruin. It won't be reactive as there's a plan in place. It won't panic as it has safeguarding and has considered that and protection measures. And ultimately, by doing so, it will look to avoid formal insolvency. As I said at the outset, we want to focus on the more positive aspects, but we will touch on what the insolvency aspects of the road to ruin are at the end of the webinar. But the focus we want to have is more of a positive one on the road to recovery, and what practical steps can be put in place to prevent a charity hitting this fork in the road, or if a charity does come to this juncture, what it can do to turn things around.
And in order to know where you are along this road to recovery and hopefully avoid that road to ruin, it's important to keep a close eye on your financial dashboards, which we think can be divided into 3 stages. The first of which is the solvent stage. And just because the charity is experiencing a downturn in donations or a period of distress, it does not automatically mean that the charity is insolvent with no prospect of recovery. The charity might still be unquestionably solvent, and capable to returning to its previous level of performance. And during this solvent stage, the directors and trustees of the charity will exclusively owe duties of care to the shareholders and beneficiaries, duties to act in the charity's best interest and promote its purposes. But if the crisis does deepen and the charity begins to border on insolvency, these duties will change, as the charity has now entered the zone of insolvency. At this stage, the charity directors and trustees will need to balance the interest of shareholders against the interest of creditors. What this means is that you can still take action in order to try to turn round the fortunes of a charity and pull that dial back into the green, but you can't be unfairly prejudicial to creditors when doing so. So it's very difficult to articulate what this might mean in the abstract, but as a high-level example, if there is a turnaround opportunity with a medium likelihood of success, but if it fails, it would be extremely prejudicial to creditors due to the high costs involved, you'd probably want to avoid that option and instead go down a route that has a lower likelihood of success, but which has caused minimal risk to creditors as there's no costs involved. And the reason for that is the Supreme Court in the recent decision of Sequana were very clear. When the charity becomes insolvent, an administration or liquidation or another insolvency procedure is imminent, unavoidable, and inevitable, then the directors and trustees' duties to creditors become paramount. You're no longer interested in the shareholders and beneficiaries' interests, and your focus needs to be on maximising the return to creditors on the wind-up of the charity's affairs. It's very difficult to know what exactly is required of directors and trustees at any particular time, which is why it's important that your clients are seeking advice from accountants and solicitors at an early stage in order to understand what their duties mean. Now, I know that Sam and I are supposed to be promoting these dashboards, but in truth, they're no use to any of us unless we understand the tests that are used to determine whether or not a charity is insolvent. And thankfully, as you'll notice throughout this presentation, the tests used to assess a charity solvency are the exact same as those that are used to assess a commercial ventures. So I don't need to tell you much about the cash flow test and the balance sheet test, both of which you're already very familiar with. The cash flow test is very simply, can the charity pay its debts as they fall due? Whilst the balance sheet test asks, do the charity's assets exceed its liabilities? But as you'll also notice throughout the presentation, a slight gloss is needed when applying these tests to charities. And the gloss that comes with the cash flow and balance sheet test arises from the principles of fund accounting that govern how charities operate. The first of which concerns unrestricted funds. Now, unrestricted funds are funds that can be used for any purpose. They can be used for the payment of debts, and the trustees have complete discretion. Importantly, unrestricted funds also include the funds that the trustees or directors have set aside for a particular purpose. And this is because the trustees are under a continuing duty to assess how best to use these funds for the charity. And that might include a redesignation of funds from their original purpose. So you might have trustees or directors come in to see you and talk about funds they've designated. Those funds are likely treated as unrestricted. And in short, the more unrestricted funds that a charity holds, the more flexibility the trustees and directors will have, and the less likely it is that the charity is going to be insolvent. But if, on the other hand, it's the donor that specified the purpose that the funds can be used for, well, in that case, the funds are likely to be restricted. They're going to be held on trust. They're not technically going to belong to the company. And therefore, when you're applying the cash flow and balance sheet test to assess the charity's solvency, you need to ignore the restricted funds. Unfortunately, we often come across charities that unintentionally hold restricted funds, and it all arises from how they set up their fundraisers and appeals. If, for example, a charity had a fundraiser and said, we will use all proceeds in order to build a local park, well, then the trustees and directors have to use those funds to build the park. They can't use it for any other purposes. But if instead the fundraiser was framed in more general terms along the lines of, we're holding a fundraiser and we are considering building a park with the proceeds, then the likelihood is that those funds are unrestricted and the charity trustees and directors would have greater flexibility as to how they use the charity's assets. And finally, you might also come across endowment funds, although these are rare. Endowment funds are typically parcels of land or sometimes large cash investments, which are donated to the charity on the condition that the charity is allowed to spend the income that accrues annually, but not the underlying capital. So, for example, if it was a piece of land, the charity would be able to make use of the land, and they'd also be able to spend any rent that arises from leasing out the land, but they cannot sell the underlying asset. So they're the three types of funds, and regardless of the level of restricted, unrestricted, or endowment funds that they have, all charities start their journey in the solvent stage, and the difficulty is maintaining that course.
No matter how good things are within a charity, it only takes one lapse in concentration for the car to come off the road. So as I mentioned earlier, and as Chris mentioned there, planning and safeguarding should be taking place at the outset, at the solvent stage. Over the course of the last number of years, many insolvencies have come out of left field with little to no warning. And those insolvencies have had a considerable ripple effect on the economy and on companies that seemingly were solvent. Carillion was an example within the construction industry, Anglo-Irish Bank was an example within the banking sector, and most recently, Flybe was an example within the aviation sector. So you have to plan and safeguard from day one. And how you can do that can perhaps be summarised in these 10 quick tips. The first three are the same for any business, no matter what sectors it's in, but they are equally important for the third sector. Firstly, regular board meetings and documenting of decisions. I'm sure you're bored of lawyers telling you this point, but it's absolutely key and fundamental for charity trustees. Secondly, whilst easier said than done these days, cutting costs where you can and where it's appropriate to do so. And thirdly, chasing debtors, or more so in the case of charities, this is slightly different and involves chasing donors. And while some charities seek to avoid doing this and don't like to be seen to doing it, it needs to be done, particularly where donations have been promised and you've budgeted and based your cash flows on them. But equally of importance in chasing them is being clear in the terms that those donations are made, similar to the point that Chris made. The fourth tip is more of a practical point, but it's one we're seeing a number of times recently, and it's around making timely and correct grant applications. Make sure that grant deadlines are met. Don't lose out in a grant over an incorrect form. We saw that arise last week. It's going to rise too often, and it's important that you get it right from the outset. Fifthly, where you can, diversify income. This reduces risk and protects against a potential shock. COVID-19 was actually a great catalyst for the third sector in diversifying income because they knew they needed to be one step ahead. And being one step ahead here is more important now than ever. Insurance. There is, as we'll explore shortly, risks for charity trustees, and those risks can be heightened if the charity trustee is in an unincorporated association. And as with any risk, you should insure against it. Professional trustee indemnity insurance is available. Make sure it's appropriate. Make sure you put it in place at the right time at the solvent stage, and it also extends to volunteers. In terms of the next three tips, they've all come from the Charity Commission. Because the Charity Commission has been very clear in their guidance on managing charity finances, the planning for insolvency and identifying trigger points are core duties of trustees. They expect them to be done from the outset. So trustees are expected to regularly stress test scenarios, they're expected to diversify income, and they're expected to minimise risk as part of their duty of prudence. So if you're a charity trustee, or if you advise a charity that has a number of trustees, where's their risk assessment and where are their plans around solvency? You and your clients don't have them. They need to prepare them now at this stage. And finally, every charity should review its legal structure and what the impact that legal structure could have in insolvency. Many charities, as you know, are companies limited by guarantee. They're legally incorporated entities, but many, and some we have come across recently, are not. And where they are an unincorporated association or there's an unincorporated charity, there's no limited liability, with trustees at risk of heightened personal liability. So that's the solvent stage. But no matter how much you plan and how much you safeguard, you just have to accept that sometimes things come out of left field and you find yourself sliding off the road into the zone of insolvency. The best run companies and even the best run charities encounter difficult times. But in our experience, the difference between the ones that survive and the ones that don't is often the ability of the better run charities to identify the warning signs, the flashing lights in the dashboard, and apply the brake. That, if you remember the road to recovery, allows those charities to be proactive rather than reactive and to take action rather than to panic. So what are the warning signs and when do you need to apply the brake? For ease of memory, and so you can take this away, we've set out 5 in the slide, 1 for each letter of brake. So the first warning sign might be where the charity's hitting or exceeding its borrowing limits or operating at a maximum amount of its overdraft. That should be a warning light going off from the dashboard. The second is where the income the charity is reliant on, mainly via grants, is being reduced considerably. Another light should be flashing then. Thirdly, where arrears with creditors are rising, or creditors are being pushed onto payment plans, or the charity finds itself simply having to juggle who it pays, when and how, then that should be another warning light. And perhaps when the handbrake has to be pulled is where there's a key event is cancelled or a key donor or grant that's worth over 50% of income is lost. And finally, another warning sign, and perhaps one that is quite clear, is where the available reserves are being exhausted. If all of these warning signs are going off, the charity's duties are changing.
And if you're unable to break in time, you will shift from the solvent stage into the zone of insolvency. And as mentioned earlier, your duties will change. You will no longer be able to act exclusively in the shareholders' interest. And instead, you now need to balance their interest against the interest of creditors. And the reason for this change is because you're now at that junction in the road where you could go down the left to the road of recovery, or you could alternatively take a wrong turn and crash along the road to ruin. And due to this increased risk, higher standards of care are expected from directors and trustees of charities. As Sam mentioned earlier, you will be expected to implement the crisis management plans that were put in place whilst the charity was still in the solvent stage. Each of these plans will be unique, and they'll also all be tailored to the particular trigger point that's been identified and arisen. But every plan will have the common elements of more frequent meetings at which the impact of any decision on creditors is explicitly taken into account. You always need to be careful with your documentation, but you need to take particular care during this time where you'd be expected to document decisions taken and rejected, the factors you took into account, the risks that were perceived, the impact of any decision on creditors, and why it was considered appropriate or inappropriate to take a particular risk at any particular time. Listen, we fully understand that it's difficult to maintain discipline when documenting your decisions. We understand that you'd rather be taking proactive steps to turn around the company as opposed to completing the paperwork. And we also know that you're sick of lawyers like Sam and I telling you to get your documentation in order. But it is really important. We can't overstate the importance of it because it can protect you from personal liability. During this stage, directors and trustees are at the risk of personal liability for wrongful trading, fraudulent trading, and are also at the risk of disqualification. But despite these risks, directors and trustees can and should continue to try and pull that dial back into the green. Remember, you're not yet at the stage where you have to act exclusively in the creditor's interest. Instead, you need to strike a balance, and that comes with pursuing turnaround opportunities. Now, there are many different opportunities you can pursue, but we think there's 5 in particular that it's important to be aware of. The first of which is a merger. You might be able to merge with a charity that's pursuing similar purposes or has similar goals in order to realise economies of scale. But it might be enough to turn around the charity by simply collaborating with other charities operating in the sector. The Charity Commission actively expects charities to collaborate with one another, which Sam and I initially found quite surprising because we're primarily used to dealing with commercial clients, and we would never suggest to one of them to collaborate with their competitors in order to cut costs. But the beauty of charities is They don't and shouldn't consider themselves as competing with one another. So charities might be able to generate increased revenues by having a joint fundraiser to increase their reach. They might also be able to reduce costs by sharing facilities, sharing staff, or even sharing ancillary services such as the HR function. You'll also all be familiar with the sale and leaseback arrangements, which might allow a charity to make use of an asset, but importantly, unlock the equity trapped inside via a sale. The one thing that you might need to be careful with if you're considering this option in connection with a charity is to make sure the asset isn't held on trust, part of an endowment, or part of any restricted fund. And without stating the obvious, you should also be seeking alternative sources of funding. Bank finance might be available, but due to the very high levels of interest at the minute, coupled with the fact that the charity's non-profit, you might struggle to access traditional lending, which is where Grant Tracker NI comes in. You can use your phone camera to scan the QR code on the screen and a link should pop up. And if you click on that link, it'll bring you to Grant Tracker NI, which is an extremely useful website which lists all of the grants available to charities operating in Northern Ireland. And you can filter those grants by whether they're currently open, the amount of funding that's available, and the eligibility criteria. You do need to pay a small annual fee of around £150 to access all of the membership, but this could be an invaluable source and a value add to pass on to your clients if it allows the directors and trustees to identify new sources of funding. It's also a very low risk option from the creditor's perspective, so you're unlikely to be criticised for taking this approach whilst you're in this zone of insolvency. The final two turnaround opportunities to flag are unique to charities, and the first of which is the release of endowment funds. If you are on the zone of insolvency, but you realise that if you could just sell that endowed asset, you would actually be pulled back into the green, then you can release that upon an application to the Charity Commission. You need to apply to the Charity Commission whenever the income of the charity is more than £1,000 a year and the value of the asset is more than 10,000. But that will be the case in virtually every circumstance, given that endowment funds typically involve parcels of land. The application is relatively simple and straightforward. You apply online and you provide the Charity Commission with evidence of the asset's value, the income of the charity, a board minute listing the reasons why it was considered appropriate to release endowment funds, and finally, a resolution of the board of directors and trustees authorising the release of endowment funds in the circumstances. And along a similar vein, you might also be able to unrestrict some of those restricted funds that you held. The simplest way of doing so is by going back to the donor and just asking them whether they're happy for the funds to be used for an alternative purpose. We think that, and we often find that donors are very willing for the funds to be reallocated, primarily because the alternative is the donor taking the funds back, and nobody wants to be seen as the person taking funds out of a charity's pockets. But one caveat that you need to be aware of, and which often catches people out, is you can only go back to the donor whenever they reserved their rights to revoke the trust. If they didn't make this reservation of rights at the outset when they made the donation, then the donor can never release the funds. And instead, similar to the way endowment funds operate, you're going to need to apply to the Charity Commission to get those restricted funds released. But it's also worth mentioning that you might also seek some legal advice to see whether the funds are truly restricted. In order to create a restricted pot of funds, you need to have the three certainties of subject matter, objects, and intention. And simply, they're often not there, which means that funds that charities have been mistaken treating as restricted are actually unrestricted, and it kind of unlocks a whole new world of possibilities for the trustees and the directors.
Sometimes, and unfortunately, though, it's not possible to turn around, or it's not possible to turn around without a formal insolvency process. And in some situations, that may mean that you're reaching the end of the road. In other situations, it may mean that an insolvency procedure can be used to allow you to get back on the road to recovery. So in this final slide, what we're hoping to do for completeness is to briefly address what sort of turnaround or recovery options there are within insolvency processes, i.e. that they're not just terminal. The first option, to possibly push a charity back into the recovery mode and back onto the road to recovery, is the use of a company voluntary arrangement or a CVA. Such arrangements can be particularly useful where charities have considerable unsecured debt, and in that case they could look to offer a pence in the pound settlement to wipe the slate clean. Whilst it would be a formal insolvency process that they would enter into, it would all be with the aim of them paying that pence in the pound settlement to wipe the slate clean and then exiting out the other side. That, in a sense, would move them off a road to ruin and back onto a road to recovery. And with incorporated charities, so limited companies or companies limited by guarantee, the advantage to the CVA is that if the requisite majority of creditors is achieved, 75%, it can bind dissenting creditors. That isn't the case, though, if there's an unincorporated association. If the charity is an unincorporated association, going back to the planning and safeguarding stage, the CVA route won't be available, so they wouldn't be able to avail of it. What they would have to do if they wanted to deal with unsecured debts, and it would be a more informal process of going down the route of trying to agree settlements with all creditors, and that would have to be individual settlements because there could be no ability to bind dissenting creditors. So CVA is one option. Another option, which could also allow a charity to get back onto the road to recovery, is administration. Now, many of you may equate administration as an insolvency event. It is an insolvency event, and administration can ultimately be terminable for a company. But the overall objective and purpose of administration, or the primary purpose of administration, is to rescue a company or a charity, for that matter, as a going concern. And how administration does that is it places the protective bubble around the charity in the form of the statutory moratorium. And an experienced insolvency practitioner can go in there and they can seek to see, can the charity be rescued as a going concern? Can it be recapitalised? Is there anything in terms of how the business is run be done differently in order to make it more financially viable? But again, the same point as I mentioned with the CVA applies. The legal structure of the charity is important. If it is incorporated, it can benefit from administration. But if it is an unincorporated association, this option won't be available. Again, showing the importance of getting the legal structure right at the outset in the solvent stage. Unfortunately, sometimes the end of the road just arrives. And it may be that you can't apply any of the turnaround options that Chris outlined, or you can't use administration or CVA. And if that isn't possible and the charity can't be rescued, then liquidation may very well spell the end of the road for the charity. Liquidation is a terminal event, and different to the CVA and the administration, it is an insolvency procedure that is available to both incorporated, so legally limited liability companies or limited by guarantee companies, and unincorporated charities. But it all needs to be borne in mind that sometimes when dealing within the third sector, it isn't as simple as making the decision yourself. And the end of the road might not be entirely within your control. And charity trustees can sometimes be sideswiped in the sense that if there's a suspicion of mismanagement, the charity commission may intervene. And we've seen that happen a number of times before. If the charity commission suspects that there's been some dishonesty or bad faith or just simply financial mismanagement within a charity, they can open an inquiry and then appoint an interim manager to conduct an investigation. This takes some of the pressure away from the charity trustees in terms of the running of the business, but the focus will firmly come on them in terms of their role in why the business got to that stage and why the charity got to that stage. The focus of the interim receiver will be on whether or not the charity remains financially viable. The one overarching point, though, you'll have noted throughout that and throughout the insolvency options, but also throughout the webinar where we discuss the different risks, is it ultimately depends on whether a charity is incorporated or unincorporated. And this is really important at the planning stage, as there are massive implications that arise from a charity's legal structure. If the charity is unincorporated, it has no legal personality and it has no protection for the charity trustees in terms of limited liability. The charity trustee's role is much more significant in that scenario, and their risk is also heightened. They will, because there's no limited company, hold the assets of the charity in trust, and they will be liable on a joint and several basis with the other charity trustees for the debts of the charity. So unlike the trustees of an incorporated charity, who are slightly more protected, the charity trustees of an unincorporated charity could be subject to insolvency proceedings themselves in the form of bankruptcy. And that is a significant risk for them. So to close, we've tried to stick, I say, to our 40 minutes to allow a couple of questions. There are really 4 key takeaways when you're looking at the zone of insolvency and where you find yourself along the various dashboards that are at the left of the slide. The first is, and the good news is, largely the same principles apply to managing insolvency risk in charities in distress that apply to advising commercial ventures. This, I suppose, is the case regardless of where you are on the dashboards. But where you're advising within the third sector and where you're advising charities, there are 3 additional things to watch out for. Firstly, take care around fund accounting, noting the different types of funds. Chris has talked about restricted funds, unrestricted funds, and endowed funds. We have seen it numerous times where a charity believes that it is cash flow solvent or balance sheet solvent, but is not taking into account the fact that there's significant funds there that are restricted, that they can only be used for a certain purpose and therefore aren't there and available for their general use. This is a key difference and something to watch out for. Secondly, as charity trustees are dealing with charitable as opposed to commercial property, higher standards of care will be expected of them. That is just the case when you operate as a charity trustee, and you will be expected to have higher level of care exerted upon you when you're dealing with those assets. And finally, not to labour the point too much, but significant risks exist if the charity is unincorporated. And for those organisations that are unincorporated, we would strongly recommend the consideration is given to them now at a stage where they're probably solvent to their legal structure, because that can have massive implications for their turnaround options, and it can also have significant implications for those who are charity trustees who they want to become charity trustees within that organisation. That concludes the webinar in terms of what Chris and I want to say this afternoon. I hope you all found it interesting and informative. We did deliberately leave a short window for some questions, but we are of course happy to take a couple if there are any. Thank you very much.
Thank you, Sam and Chris, for that excellent presentation. I know on the Charity Not-for-Profit Group, we are focusing a lot of our attentions on sustainability and survival for charities. So any advice is greatly appreciated, because most of the people on this webinar will either be involved with charities or advising charities or both. There's one question at the minute in the Q&A box, and I'll just read it out. If there is a solvent closure of a charity and funds are left in the bank following payment of creditors, how is this dealt with? And is there any legal documentation needed to state that this will be distributed to beneficiaries? Do you need me to repeat that, or can you see it?
No, I think we've had that similar issue before. Rosemary, Chris, you had that before recently, didn't you?
Yes, I think what you would do in that scenario is the first thing you go back to is you identify how the charity has been incorporated, which will typically be a charity incorporated by guarantee. They would typically have objects clause or restrictions in them to the effect that whenever charities wind up, instead of the monies reverting back to the members of the company, it's applied to a charitable purpose. So that's often referred to as a C-praise scheme, where the funds would need to be applied by the trustees to a charity that's pursuing similar endeavours, but not quite. So the task of the trustees and directors and the whatever insolvency practitioner, if they assisted in winding up the affairs of the charity, would be to find an alternative charitable body that can take those funds and use them to consider achieve the purposes. So it's not going to flow back to the guarantors or the members.
Thank you. And just one general one, I suppose. You've talked there a lot about the use of restricted funds and how that can operate. So if you're a charity trustee, what would you do to make sure that restricted funds are used for the purpose they should be? And what can they do, I suppose? I mean, I know from a lot of clients we would have, it's very tempting. There's not much in unrestricted funds. There's quite a bit in restricted, how they get access to it, and what happens when they hit the rails, as down to the Charity Commission then to say what can be done with those funds.
Yeah, Rosemary, unfortunately, it often can be down to the Charity Commission what happens. In terms of what you can do with the restricted funds, it's difficult to answer in the abstract. You kind of need to pay very careful attention to the terms of the restriction. If, for example, the terms of the restriction are quite broad, say it could be general improvement of facilities, there's a lot you can do there. if there's a much tighter definition, you know, we're going to use these funds to build disability ramps, then you're quite limited to what you can do, and you would need to apply to get release from permission to use the funds for an alternative purpose. The other points to bear in mind, though, is you should always go back to the fundraiser and appeal and check what exact terms there were on the donation forms and things like that, because it often is important where there's a secondary purpose. There tends to be a general catch-all. And if you're using documentation prepared by the Charity Commission, they would always recommend to have that general catch-all so that you avoid the situation where you're stuck with a load of restricted funds. And if there's not the general catch-all, hopefully there's that reservation of rights that the donor's made, in which case, if you tracked the donor, you could go back to the donor and the donor might be able to give you permission to release the funds and use them for something else.
I don't see any other questions at the minute. I suppose one thing that struck me, and we know this anyway, but a lot of charity trustees aren't aware of the fact that the same onus is on them. In fact, a higher level of responsibility, as you said in your presentation, around director disqualification and their roles and duties there. And I think a lot of charity trustees maybe think, well, I'm doing this for nothing. It's a good thing I'm doing, and they don't realise. So I think it's on us, incumbent upon us as advisors to make sure they're all aware of that.
Yeah, I think, Rosemary, in any situation where there's a company, whether it's a charity or otherwise, and it enters into insolvency proceedings, the charity trustees can be subject to directors' qualification proceedings, and that is kind of heightened in two respects for them. One, they're doing it for charitable purposes, not commercial venture, and we don't want to discourage this, and the law doesn't want to discourage them doing that. And secondly, they'll be involved in other ventures. Well, you may sit in other boards, they may be involved in commercial ventures, and that then heightens a risk for them. But I suppose the one thing I would say is, just when a company goes into insolvency, it's for the official receiver or the insolvency practitioner who's appointed to report on the conduct of the directors. And just because it goes into insolvency doesn't necessarily mean that it follows that there will be a disqualification. The Department of Economy would have to consider that. They'd have to bring in an application, and there would need to be some conduct on the part of the charity trustees in the period prior to the insolvency that justified it. And the most obvious ones would be, the likes of misapplication of charity funds or a breach of trust. But what sometimes scares charity trustees is that they see company directors within commercial ventures being disqualified for failing to keep proper accounting records or submit returns or prepare accounts, and they can sort of be seen as some sort of minor failings. But the one sort of good point I would say is that the third sector disqualification applications have been few and far between. They've been really rare. You might have recalled, or some of your clients might have recalled, that there was quite a high-profile one that went on during COVID, which was against charity trustees following the insolvency of Kids Company in the UK. What was really strange about that is that there were no allegations of dishonesty or bad faith or inappropriate gain, but the official receiver decided to pursue the application on the basis that the trustees were operating an unsustainable business model. And the real good news from that is the charity trustees won, the official receiver lost, and the court refused to make those orders. And the main positive coming out is the courts pretty much were saying, look, we do hold them higher, charity trustees, because they hold charitable property and they hold property that isn't for commercial. But unless there's circumstances of dishonesty or willful misconduct, we don't really want to get involved in looking at it. And it was a bit of a warning, I think, the judge was giving there to the official receiver, which is maybe why we won't see them again, is that unless you're bringing to the court the clearest of cases, there's a big risk that you deter, able and experienced individuals from becoming or remaining charity trustees. So the court was quite keen to strike a balance in that case, that they didn't want to have detriment to the charity sector. So I don't think, yes, there is that risk, and obviously lawyers and accountants often paint risks to clients, but I don't think we'll see many applications such as we saw in Kids Company or directors' disqualification applications in the future, unless you can show that there's real dishonesty or bad faith on the part of the charity trustees.
Okay, thank you. I don't see any other questions from anyone. Just a final wee chance. No? Well, just remains for me then to thank Sam and Chris for their excellent presentation, very informative, very useful, and I'm sure everybody will have learned something from it. So thank you both very much for that.
No problem. Thank you.
Goodbye, everybody.